Okay, so this is LAWS 13013, Legal Professional Conduct, Week 1. We're looking at accountability and responsibility, and in particular, tonight we're going to have a look at tutorial problems 1 through 6. I see we've got Luke. Luke, what's your surname? I'm just going to keep a roll of people who attend, that's all.
Luke Collins.
Oh, Collins, okay, thank you. All right, so as long as everybody's aware of the fact that this is being recorded, and we'll put it up on YouTube and back into Moodle as well. Okay, so what I'll do is I'll just stop sharing that. So now I can actually see everybody, which makes it a bit easier to cope with. All right, well, thanks for coming along to this evening's session. I'll be running these sessions every week for the duration of the course. The idea is to give you an opportunity to talk about the various tutorial questions and any other problems you have you might be encountering with the course itself. So what you did in the first week was to start looking at what accountability and responsibility meant. So we wanted to understand about what a profession is, look at what the distinctions are between things like morality and ethics and those sorts of concepts. And it's a little bit different, I suppose, the first week from the rest of the course, because the rest of the course is going to focus really heavily on things like the professional conduct rules. When you get out into practice, all sorts of ethical issues are going to come your way, and I'll be showing you various examples of these as we go through the course. So the classic one was the icebreaker activity, which is the current debate going on between the government and the profession about the role of defence counsel and what have you. So I put that up there in the cartoon as well because there's various other issues come up with issues. Another example was on Rake. I don't know if any of you watched Rake earlier this week. Do you know what Rake is? It's a program. I think it's on the ABC, but it's portraying a rather dubious barrister that gets himself in all sorts of trouble. And there was a good ethical point came out this week, which I'll see if I can extract parts out of the actual program, and I'll put that up in the relevant week. Another thing that happened this week is that there was a lawyer who wrote a will, which ended up wrote a will for a client, which ended up benefiting an associate of the law firm itself. So that's another ethical issue that came in the paper this week. So what I suppose I'm trying to say is these ethical issues happen all the time. And what I'm hoping you'll get out of this course is the ability to be able to recognise when you're confronted with an ethical problem, be able to link that back into the professional rules to see whether they govern the particular situation or not, and then come up with an appropriate response. Because often you have to do make these sorts of decisions really quickly, and you don't want to end up on the wrong side of a misconduct case. So that's the whole aim of this, is to protect you in practice. So it's a really important topic, so don't underestimate it. The other thing I'd just like to point out at this point as well is that week 4 is particularly heavy in terms of content. What I'd like you to try and do is to get ahead a little bit in the first 3 weeks, so that it'll free you up to spend a bit more time looking at the issues in week 4, which deals with money matters. That's about trust accounting, and it's about handling clients' money. That's the area that has the most significant professional misconduct cases. So it's really important to come to grips with that particular topic.
Jessica, get Jeff to put his microphone on mute, because you keep going to the background noise, because his moving around is making it a bit fuzzy.
Oh, okay. Yeah, Jeff, if you wouldn't mind just muting your microphone. That's it. Thanks very much. Yeah. So everybody should mute there. I won't mute mine because I've got to say something. But if people want to, people want to say something, interject, by all means do that. Otherwise, I'll end up going hoarse because I can't stop talking. So if you've got any questions, just ask them. Okay, I haven't bitten anybody in years, so you're pretty safe. So, all right. Okay, are there any questions about the course overall at this point? I know you've only just started. Anybody got any particular concerns or questions?
Yeah, Stephen, with the quizzes, can you just confirm those dates? Because it looked, from reading the profile, it looked to me like there was two separate dates, and it wasn't altogether clear.
Okay, there's two separate quizzes, and what'll essentially happen is that you'll have a 24-hour period in which to log in to do the quiz, and I'm designing them to be about an hour for you to complete. So you can start the quiz at any point within the 24 hours, and you've got an hour to complete it. So there's two quizzes, and they cover different parts of the course. I can't remember the exact dates, but I think the first one, it might be towards the end of week 4, and it covers, actually, I'll have a quick look. Just having a look through the, having a look at the Moodle site at the moment. If you click on quiz 1, it covers weeks 1 to 5. Okay, so you get one attempt at it, and it covers an hour. So it's a bit like a mid-semester test, except it's done online. So the sorts of, I haven't written any of this yet, but the sorts of questions there'll probably be some multi-choice type questions and some short answer questions. Excuse me. The whole aim of it is to encourage you to actually study the material and make sure you're getting comfortable with it as you go through. I'm also trying to avoid having a final exam. And most subjects have final exams. This one doesn't. It's got a couple of quizzes, some class participation, and also it's got a couple of assignments, I think. So you won't have a final exam in this subject. All right. Look, I'll give you more details about the quiz closer to the time, especially after when I've had a chance to actually write the questions. So, but it'll be based on the readings. It'll be based on the actual rules themselves. I don't think it'll be terribly difficult, but as I say, I'll let you know more about that closer to the time. All right. What I've done, I've given you all the materials essentially right through to the end of the course. The only thing at the end is that there's a client interviewing exercise where you'll actually have to do 3 client interviews in different capacities, one as a client, one as the person conducting the interview, and also one as an observer. So the idea is to get you to engage in client interviewing. That'll be relevant because in some of the other subjects, we're aiming to introduce some clinical practice where you'll be involved with community legal centres, and you'll have real clients, and you'll have to conduct client interviews under the supervision of a solicitor. So some of these things have consequences in later subjects. So it's a good idea to start to get some practice on what these things entail. So there'll be a week devoted to that. Okay. All right. Look, if there's no other questions, we might actually start and have a look at some of these, the actual tutorial problems, and there's 6 of them. It's really pleasing to see people are starting to put up lots of posts on the site. Often you see in these sites people don't participate, but it's really important to participate. And if you get a chance to form some study groups with people around you, whether in the same vicinity, or if you can form some links online to discuss these issues, because quite often there are different viewpoints. One of these students who's got an Indigenous background, she actually posted up some comments which I thought were quite interesting in looking at some of these issues from an Indigenous perspective, because it gives you a different sort of appreciation and slant on what you're looking at. Okay, enough said. Let's let's have a look at the first problem. So essentially what we've got is a question: why are lawyers said to be professionals but business people are not? What makes someone a member of a profession? Okay, who's got some suggestions in relation to that?
Operate this thing.
Okay, well, we can hear you, but nice and loud.
Oh my goodness, you can hear me?
Absolutely.
Oh no, I'm talking by myself here.
That's all right, Anthony.
Oh, that's scary. Well, I've written down here, like, you have to have knowledge and education of the profession that you are wanting to work in, testing the competence of members, have to be an organisation, code of conduct, and altruistic services.
Okay. All right. No, that's good. So I might ask you, we can actually see you too, by the way.
I know, it's terrifying.
Don't be worried. It's okay. I suppose I'm used to it because everything I've ever done's been recorded since for like almost the last
I've
4
never
years.
seen myself and being actually online with a lecturer. It's absolutely terrifying.
Well, as I said earlier, I haven't bitten anybody, so you're pretty safe. So,
Plus, I've got sleeping kids as well in one room down there, and I'm trying to keep them quiet. And I didn't know that you guys were actually listening.
you can mute your microphone, by the way.
Oh, can you? Well, I don't know how to do that.
Okay, all right. Well, I think we'll be all right as long as
Doesn't
you
matter.
don't start screaming at us. Okay, all right. So what you've done so far is you've given us some of the factors which are listed under various traits of a profession. Okay.
Yeah.
There's 2 main approaches. One is that. What's the other one? Does anybody know? We don't want Anthea answering every question because she can't turn a microphone on.
Oh, there's the resource and power approach.
Okay, what's that?
I don't know. I didn't have time to look at it.
Okay. Well, who's going to help her? What's the source and power approach?
Guys, I got my teacher here. You guys need to go to bed. Go. Sissy, get out of here. Go.
All right, Anthony's a bit occupied now, so come on, help her out. What's the source and power approach?
Yes.
Does anybody know?
Go and watch Home and Away. Go. Down.
Oh dear. Well, no one knows. Well, look, that approach is looking at the legal profession and its economic power and the control it has within the marketplace. Why would the legal profession have control in its marketplace? What gives it that control? Anybody know? Amanda, you're looking like you should know the answer to that. Do you know? How does the legal profession get its power? What about you, Luke? Have you got a suggestion?
No sleep. Now, good night.
I would think that it's because of their position. It's quite a monopoly.
That's right. It's a monopoly. Where does it get that monopoly power from?
Is it the Code of Professional Conduct?
Yeah. Okay. It gets it. That's sort of partially right. It gets it from the legislation. It gets it from the legislation, which sets up an offence for somebody to conduct business as a solicitor if they're unqualified, if they haven't met the requirements of admission. So that's how it gets its power. There are some areas where that power is being challenged by accountancy firms, because you see accountancy firms can also give client advice in relation to certain matters as well. So you see lawyers starting to, they work in accountancy firms as well. And you also see another area, not in Queensland so much.
Only financial planners can give advice, actually. Normal accountants can't.
Yep, the financial planners can. Another area that's clearer is conveyancing. You get conveyancers who can practice in that particular field. So there is a sort of bit of a power struggle going on as to who can give legal advice. So it's under challenge in some respects. Okay, all right. So what other characteristics are there? What's the key distinction between the lawyers as a profession and business, or a profession and a business? What's the key difference? What are the main things? We've heard a few, but what do you think is the main difference?
Membership?
Well, certainly you can become a member of a profession. That's certainly true. Can you become a member of a business? You could become a member of a professional or like a society that governs a particular business area. So,
what about admission? Like having a certificate, a piece of paper that states that you're a lawyer, and saying that you're able to work in this industry or this area.
okay, so there are restrictions to entry. So
Yeah.
can you think of any businesses that have restrictions to entry that aren't professions? What are the traditional professions?
Doctors,
Doctors, lawyers,
Accountants.
teachers,
clergy. Then you're starting to, they're the traditional ones. Then you have other sorts of areas. What about somebody like a sound technician? Is that a profession?
no.
Okay, well, maybe maybe that's not a good.
What about
a nurse?
IT?
What about a nurse?
A
Let's
nurse?
look at nursing. Okay, nurses would regard themselves as being in the nursing profession, wouldn't they?
Yeah.
And what is it about what they do that makes them members of the profession?
Well, they're part of like the medical board.
Well, there's a nursing board, so there are there are limitations to entry into the profession. You've got to have certain training.
Yeah.
They have this notion of a public service, not a profit. That's quite an important one. That professions don't have this sole profit motive. They have a public service element. So in relation to law, it's to the due administration of justice. They're an officer of the court. You see what I mean? So they have, there's this extra couple of elements
Well,
about...
is that altruistic service?
That's altruistic service, that's right. So that reflects itself in things like pro bono work. It reflects itself in if there's a conflict between the duty to the court and profit, they should have their motives based on duty to the court, to the due administration of justice, because if they breach those sorts of requirements, then they can end up in a situation where they can be thrown out of the profession. So they're the sorts of things that are the differences between professions and businesses. Okay. What about, do you think a great lawyer is a person who makes plenty of money as a rainmaker? There was those John Grisham films, the Rainmaker and those sorts of things. Is that what a lawyer is about? Is that what it means to be a great lawyer, if you can generate lots of income?
No.
It might be for the partners in the firm, but in terms of the broader audience of the profession, that's not necessarily what a great lawyer is all about. It's more about the service. And, they certainly can make a good living in practicing the law, but it's about service as well.
Sweet.
Okay. Yeah. So that's probably enough on that question. What I'm going to do is there's plenty of discussion on the actual forums as well. You should have a look at that because there's some really good comments made by various people. So they're certainly worth reading. There was a good comment by Michael Nelson when I was looking through the various posts as well. So he sets out quite a lot of good points. So it's worthwhile having a look at what he has to say along with some of the others. And I've made comments on various ones as well. And what I'll do is I will post up a suggested solution. I mean, there's no real definitive answer to a lot of these questions, as you'll discover. It's more about thinking about what the issues are and trying to isolate the key ones. Okay, all right, we'll move on because we've got 6 problems to deal with. The next one deals with a classification, and there'll be some debate about this. So the distinction is between what is an ethical issue, what is etiquette, what's courtesy, and what's morality. So I thought before we look at each of these things, we might actually try and work out what ethics actually means. Does anybody have any idea on what ethics means?
It's a strong set of rules that you have to abide by.
Okay, that's right. That's a more sort of a modern definition of it. The traditional definition was about trustworthiness or credibility, but in the modern interpretation of what it means, it's about morals, the science of morals, rules of conduct or values, and rules of individual conduct. So that's what we're going to be looking at in this course, and in particular in relation to a particular professional group, namely lawyers, both barristers and solicitors. So that's what ethics is about. What's morals? How would you define what a moral is? Or what do morals mean or deal with?
One's own value system.
Okay, that's true. So the most fundamental example of that would be the distinction between what's right and wrong. And it's really good how you put that, because it's one's own value system, because you have to look at it from the perspective of different people, because people can have different moral attitudes to particular things. Like for a classic example would be, you know how we export live sheep to Muslim countries? How those particular animals are treated in some societies is seen as perfectly fine, yet in others it's not. So it depends on your moral. It depends on your perception of right and wrong. So that's just an example. There's lots of examples. So that's really what morals is about. What about something like etiquette? What's etiquette?
How you behave.
How you behave. Yeah. Can you elaborate a little bit on that?
I was saying that ethics is the reason why you would think to do something, and etiquette is the way that you conduct yourself.
Yeah, it's true. It's about your personal behaviour and how you acquit yourself or operate, but it's also viewed in terms of like a polite society, what polite society would do. So in a professional context, it's largely an unwritten code, and it's all designed to maintain the dignity of the profession. So if we were trying to put these things in a list, the highest order things would be the ethical requirements. Then that's judged in the context of the morality of the person. Etiquette is a lot lower down the pecking order in terms of behaviour. What about courtesy? What's that about? What does courtesy mean?
Manners and consideration.
That's right. So it's consideration of others. Okay. All right. So we've got some definitions there. So I thought what we might do is now have a look at these particular items that we've got. So the first one that we've got is a senior counsel carrying a red book bag. Okay, I don't know if you know the history of these things. There's red book bags and there's blue book bags. The red one's the senior counsel, the blue one's the junior counsel. So what would that be?
Etiquette.
So that really essentially is an issue of etiquette, isn't it?
Yeah.
Yeah, exactly. So that's the category that would fall under. So that's good. What about the next one? Arguing with a judge over the admissibility or otherwise of evidence. What about
Ethics?
That's an ethics issue. Now, why did you put it in that category? I think you're right, but why did you put it there?
Because that's just, I don't know how it is, that you shouldn't argue with a judge because they're your superior.
That's essentially what it is, because the judge is there is ruling on the admissibility or otherwise of evidence. It didn't say making submissions in relation to the admissibility or otherwise. It was saying arguing against the judge. So this is in effect an attack on the administration of justice. So that's why it fits within the category of a breach of ethics rather than some of the lower category. Okay, all right, we'll keep going. Look, if you've got any disagreements or questions, just raise them. Some of these are quite fine distinctions. What about the third one? Using your experience to outwit an inexperienced opponent. What do you think that would be?
Courtesy? I would think courtesy.
Morality.
Okay, so we've got courtesy and morality. Why do you think it's morality?
Because it's up to your own set of values as to whether you're prepared to do that. I don't think it's courtesy because it's something that would be allowed and in the heat of a court case or whatever. And I think that if you were that way morally persuaded that the person's inexperience might be seen as a sort of way for you to win the case.
Yeah, I actually think it's more morality than courtesy. It's definitely not etiquette and it's not a breach of ethics. Yep. You're allowed to do it. But I think it's more of a moral question. I think in the reality, most experienced people wouldn't be overly concerned about this. It's just bad luck. Yeah. You get experience. It's up to the client who they get to represent them and, of course, who they can afford and their abilities. So I think it's more a morality. What about failing to pay a parking ticket? What do you think about that one?
Morals.
Okay, yeah, I think it is morals. That in itself is not enough to be a breach of ethics. So some people might come along and argue, no, you're breaking the law and therefore that's a breach of the ethical rules. But it's such a minor thing that it's going to fall within the morality category rather than the higher level breach of ethics. Mind you, if you had hundreds of parking fines and you total disregard of the law, and I can give you an example of that. There was a barrister that used to park on the edge of the freeway across from the Inns of Court in Brisbane and did so for many years and accumulated thousands and thousands of fines and was taken to court by the local council and the council lost and then they had to put up more signs. And, that was getting to the point where it was a breach of ethics, but in the sense of disregard for the law. But in our particular case, I think it's more a moral issue. Okay, failing to attend scheduled appointments with clients. What about that?
Ethics.
That's an ethics issue. Why is it an ethics issue?
I think because you have a duty to the client
That's
as well.
Exactly right.
So
yeah, you have a duty of care. You have a contractual duty, but you also have a duty of care in representing a client. So if you're not turning up to appointments with the client, then you're not representing them properly. Of course, all these things depend on how often it happens and the gravity of it, but that's the sort of line you'd argue there. What about failing to attend scheduled appointments with practitioners?
That's the same, also ethics?
Again, it's an ethics issue. There's multiple instances of this. You see, what the problem with this is that it starts to be problematic in terms of the administration of justice because the work can't be done because these appointments are being missed. So that's why it's heading down the path of an ethical issue. All right, ignoring clients' repeated requests for information and updates about their case. What about that one?
Ethics.
Ethics, again, you're not representing the client properly. And we'll be looking at all the rules in relation to this later on in the course, and you'll see where all these things come from. What about this one? A lawyer convicted of manslaughter for killing a pedestrian with a car while drink driving. What about that?
I put ethics and morality.
Okay, yeah, I suppose it's certainly a breach of ethics, and it would be probably a breach of morals as well. But it's really akin to Zymes's case, that situation. And in that case, you saw somebody who was, while they were incarcerated, they were also effectively struck off the profession. It wasn't really that much of a penalty because they couldn't practice in jail anyway, unless they're going to advise the criminals there. But that's Zymes's case, which you should read at some point. Okay, ignoring a law student's request for an interview.
courtesy.
Okay, that's more of a courtesy. type issue? A lack of courtesy. What about a lawyer campaigning to make euthanasia legal?
It's morality.
That's a morality issue. Okay. All right, so the purpose of this exercise was to give you some examples and then to help you come to grips with the differences in meanings of these different types of concepts. Okay, so that was the whole exercise there. All right, any questions about any of that?
No.
Okay,
No.
all right. Let's move on to problem 3. So this required you to have a read of Michael Kirby's article. Incidentally, Michael Kirby's going to be at a graduation in Rockhampton tomorrow. If any of you are in that area, it's probably a good time to go and meet him. I'm flying up there tomorrow for that purpose. So, and he's a good supporter of our little law discipline as well. So anyway, he wrote this article about legal professional ethics in times of change. And he basically came up with some basic notions. The way to address this, I think, is to look at each of these notions in turn. So the first one he said, the basic questions which are posed are these: is such expressed anxiety nothing more than a nostalgic hankering for a return to the good old days of legal practice, which were not so good for the consumer after all? Okay, so just looking at that particular phrase, have you got any comments about that? About this hankering to return to the good old days of legal practice? Is that what legal practice was like? It wasn't very good for the consumer?
I haven't read the article, but what anxieties are you referring to?
Okay, so I think there was an anxiety amongst the profession that that really what's happening is it was turning into a business, and that it wasn't really maintaining its professional roots. So what did other people think? So the traditional aspect of all of this is that people were to trust their lawyers, and it was for that reason, and because they had this professional capacity, that they were given this monopoly to practice and represent other people in court. And there was also these ideas that barristers could only appear when briefed by a solicitor, that a QC or a senior counsel could only appear with a junior, and all of that resulted in increased costs. Now, a lot of those sorts of rules have gone by the wayside, so you can have, senior counsel appearing without juniors, although it's not that common that you can't have that. Do people trust their lawyers? What do you think about that idea?
I thought that maybe they sort of referred to the fact that back in the day people didn't question their lawyers and they probably believed everything they were told, but now with the internet a lot of people do research and come up with answers on their own.
That's certainly the case. There's a lot more questions.
I actually thought it might, sorry.
Go on.
I was just going to say, I thought it might actually have something to do with the Americanization, broadcasting lawyers as blood-sucking money grabbers. The US really portrays lawyers in a very negative light. I thought it might be something to do with that.
Yeah, you've never worked in a large law firm, have you?
Isn't that obvious?
That's a little bit closer to home, actually. I worked in a really large national firm for a while, and they were pretty ruthless when it came to money. But I suppose they were actually more ruthless than American firms. The Queensland firms actually required longer billing hours per day than New York law firms at that time. That was a few years back. So, So sorry.
Stephen, I mean, when you talk about referring back to the old days, it's probably a bit of a protectionist idea that, if you can keep something rare, you keep its value, a bit like diamonds or whatever. And that was the idea that if they could keep it a closed shop, well, then they can keep the value of the profession going.
That's right. It's a bit like specialist doctors, isn't it? There's so few specialty places that they can restrict the actual availability of service providers. So you've still got an increasing, like an aging population and an increasing clientele, and you increase the profits that are available through the monopoly by, restricting the number of providers. But these days, there's lots of law firms now. There's no restriction on anybody, essentially, who've got their degree from setting up a firm. So there's a lot more competition, and there's a lot more international competition as well that's coming into the large firm market. And so, yeah, there's a bit of a shaking out that's been going on in the profession over the last 10 years or so. All right, look, we better keep moving or we're going to run out of time. So the next part of it was the professionalism of the past merely a self-deceiving disguise to preserve a large hold on power in society. So I just wanted to ask you, what's the link between law and power?
Where are you reading from?
No, I was just asking you the question. What's the
Problem 3.
Yeah, what's the link?
Oh, we're still on problem 3.
Yeah, we've only done the first part of it.
Okay.
What's the link between law and power?
Not many people know the law.
Who creates the law?
Power.
Sorry, Davina, say that again.
Sorry, through legislation you can create and change and become power.
You can. So you can gain significant power through legislation. It can create monopolies. Legislation can restrict the rights of some people and better the position of others. And then also you've got, from the judicial side of it, you've got the interpretation of legislation in cases, and that can affect power balances and wealth in society as well. And it's not surprising that so many politicians are actually lawyers, because they understand the effect of legislation. The other thing that should bear in mind too is the separation of powers is really important. So it's very difficult to remove judges from office. In most states, it requires a vote of both houses of parliament on proven misbehaviour or incapacity. In Queensland, we've got a unicameral situation, so there's only one house, but they're really extremely rare events. Has been known to happen in Australia, but it's very rare. So it's important to maintain that those separations of power, because the government and the judiciary have different roles. Government, judiciary, executive are the three branches. They have different roles. And this is part of this debate that's going on with the bikie legislation and removing judicial discretions and having mandatory sentencing, because that diminishes the discretionary power of the judiciary. So that's perceived as an attack on that branch of government. So there's all sorts of issues surrounding this that you would have come across in subjects like constitutional law. But it's all about power and the control that brings. The last little bit of this is this phrase, or is it our anxiety, a last desperate effort to keep alive a flame of professionalism in the face of so much evidence that the law is moving in the direction of a business, and that the idealism and selflessness of the profession is finally dying out? What evidence do we have that the law is a business as distinct from a profession?
Just the competitive nature of it now, the way you see firms advertising for their services.
That's true. So it's highly competitive in terms of advertising. Bigger law firms appoint business managers. We're seeing mergers and takeovers of different partnerships. Law firms can actually, can be incorporated companies.
Lawyers are in it for the money.
Yeah. I mean, I don't see any problem with people making a reasonable living. It's where that becomes dominant over the other aspects of the profession, it becomes problematic. How much pro bono work happens? So you'll have some statistics on pro bono work in this course. There's quite a lot of pro bono work actually happens. There's certainly an emphasis on profit and budgets and meeting budgets and accounting for every 6 minutes worth of your time. A lot more business analytics is happening. So they certainly have a lot of the characteristics of businesses and how businesses are run. So that's the sort of evidence we have. But on the other hand, you also have good examples of idealism and selflessness. So the President's Medal that was handed out last week at the Law Society's dinner was handed out to a member of a law firm who represented a client in Dubai who had been effectively jailed without trial for a long period of time. So that was all pro bono work that went on for years, unpaid.
Was that the one about the journalist?
Sorry, what was that?
Sorry, was that the one about the journalist, the Brisbane journalist in Dubai?
I can't remember whether he was a journalist or not. I'm not sure. I don't think he was a journalist. I don't actually have it in front of me to look it up, but the point was more about...
I was just curious. I'm in Brisbane and it's all over the papers and everywhere I see.
There was a journalist situation, but there was also somebody who had been locked up when they fell foul of a land deal. And I think it was the land deal one for this one. But it just goes to show that there are people out there that, will do this sort of work. And there's lots of pro bono work. You've got a lot of environmental defenders organisations, local community lawyers centres. So there's a lot of that sort of happening. So you've got these sort of two extremes, the money side of it and then the service side of it. Okay, we'll keep going. Question 4 is all about medical practitioners. And they have all of these particularly strict rules concerning sexual relationships with clients. And the question is, should lawyers be subjected to similar requirements? And then I gave you some links in there to the Code of Ethics, for doctors. So what do you think about this sort of situation? It's going to crop up a couple of times later on in the course because it's something that does happen in practice and it can get really messy if it's not handled properly. So what do the doctors say? What's their position?
I didn't actually look at the links at all, but I know there was a case recently I'm not sure where it was actually, that a doctor had taken advantage of one of his patients, and she was claiming it was illegal because she was depressed, and that he took advantage of her. It's not, I can't really think of a situation where it would relate in law. I can't imagine where someone would be so incapacitated that someone in the profession would be able to take advantage of them.
Well, you can have various sorts of incapacities, whether it be through depression or mental illness, just general distress. So, I mean, it can happen. You also have situations where it happens in reverse, where the one that's actually being pursued is the lawyer rather than the other way around. And there's certainly instances of that as well. And I did a little animation on that, which you'll see later in the course. And it was quite funny because I showed that to one of the presidents of the Law Society in another jurisdiction, and he said that exact thing happened to him. So it does happen. But what do the doctors, what does their code say?
Well, they're in a position of power.
That's right. They're in a position of power. So what does their code require them to do in a situation where they're becoming overly interested in their patient for the wrong reasons?
They would have to report it, maybe?
That particular code of ethics, it says that doctors are to avoid engaging in sexual activity with your patient.
Exactly. And it's the same position in a number of the American jurisdictions, American Bar Association rules, and in New Zealand it's the same. So you've got to avoid those situations. But in Queensland we don't have a specific rule dealing with that. So what other potential problems can arise out of this?
You could end up in a lawsuit if they could try to take advantage of you, saying that you took advantage of them, because everyone's trying to sue everybody these days.
Yeah, I mean, there's certainly a potential for conflicts of interest, and and adverse rulings against a lawyer based on conflict of interest, potentially. failing to act objectively, and there's a particular case there I referred you to of Morel, Legal Practitioners Conduct Board against Morel. It's a South Australian case. In that case, the lawyer in a criminal practice formed a personal relationship with the clients who were in prison, and this does happen. And it was found that in at least one of those relationships, she'd allowed a personal relationship to interfere with her professional duties to the client. She'd acted unprofessionally in other respects as well. And she was struck off. She was removed from the role of solicitors. So these things can have adverse consequences. So it's best to avoid them. If you can't avoid them, what you need to do is you need to remove yourself from being their representative. They should have independent counsel that doesn't involve you. So, you know, you've got to remove yourself from the situation.
Hello. Is this confusing the phone?
Okay. I'm not sure what's happening there. Okay. All right. So anyway, the main points to come out of that is it's something that should be avoided. In the later weeks, we're going to look at this again, and there's a law report, the ABC Law Report, which is a radio program. There was some interviews in relation to that for you to refer to, and I've also given the references to the New Zealand position. But at the moment, there is no strict law in Queensland dealing with that. The general,
Professor Colbran, that.
Where are we?
Say, for example, there's a case, like a criminal case, where you're going through the trial and it's a long trial and you're getting towards the end of it and then the relationship develops. Is that, like, how do you remove yourself from that situation? Because
so are you the counsel, or are you a solicitor, or does it matter?
Defending the criminal.
Okay, so you're there. Say you're their defence and you're the solicitor. Yeah. Well, basically what you should do is you should get another person in your firm to represent them. Or if you can't do that, you really should say to them they need to find another firm to represent them. If you're the counsel, it's the same situation. And there's been cases exactly on this in relation to counsel. And it's really a situation where you need to avoid the conflict. So they just have to find other representation.
But couldn't they claim, if it was at the end of the trial, couldn't they claim, claim that they've now got new counsel and they want to go in a different way, so they need a new trial?
Well, I think any replacement counsel coming into the situation will be briefed by the earlier counsel, and you can't really change tack at that point if it's late in the day. You're stuck with what has happened. There's transcripts recorded of what goes on in court. So, if you're taking over a matter, you would get copies of all of that, and you'd just have to run with the arguments. They would have already pleaded guilty or not guilty. They would already set up the offences or otherwise. So you just have to run with what you've got. But it's very inconvenient, and certainly something you don't want to have happen to you if you can avoid it. Okay, all right. Problem number 5. Should personal as distinct from professional conduct result in professional penalties? Okay, so professional misconduct, a classic example of that is where somebody steals from their trust account. Okay, so putting that aside is personal misconduct, and a good example of that is Zymes's case, where he's convicted of involuntary manslaughter arising out of drink driving, where because of the drink driving, they ended up killing somebody. And what happened was that they were given a 2-year suspension from practice, which just happened to coincide with the 2 years they got incarcerated for. So should personal misconduct result in that type of outcome? What do you think?
Just with Zymes, the interesting thing that the judges said, and they really wanted to make it clear that the idea of striking him from the role was not to punish him twice, that he'd already been punished for his crime, and it really just came down to whether he was a fit and proper person. So, but they really did emphasise that it was important that he wasn't punished twice.
Yeah, that concept flows right through all of the ethics study you'll be doing. The professional penalties that are imposed on a person are never perceived as a punishment. They're seen as a protection of the public. So that's why they've said that in Zymes's case, that it wasn't punishment. It's really designed to protect the public, and that's how all of these types of ethical issues are perceived by the judiciary. So that's certainly the case. Now, he didn't have any mens rea element or a guilty mind. He didn't have that because he was so drunk. He couldn't form that intention. So that's why it ended up as an involuntary act and ended up as manslaughter, because it didn't have the intent to become murder. But just on the broader issue, do you think it's right that personal misconduct, so things that happen outside your professional activities, should that lead to professional consequences?
I think it depends on a case-by-case basis. So if you beat your wife and you're an aggressive person and you've got AVOs against you, I think things like that should move on into the profession, because you're not an upstanding citizen. You're not a fit and healthy person to practice the law. Okay.
Now, I can tell you, I've just come off the New South Wales Legal Practitioners Board for 8 years. So when I was on that board, we dealt with all applications for admission in New South Wales, and also people who had been previously struck off trying to be readmitted. And you'd have to occasionally write judgments on whether they should or should not be admitted or not. And then there's an appeal that goes to the Court of Appeal in New South Wales. So some of these things in relation to admission, things like drink driving, multiple serious counts of drink driving are things that are taken into account as to whether somebody is a fit and proper person for admission purposes. And you'll be going through in week 3 looking at all of the requirements for admission. So they're sorts of things that will be taken into account. A mental disability or a mental illness is something that would also potentially result in a board asking for medical opinions on the mental health of a particular person seeking admission or readmission. The difficult cases, or people who have been struck off with stealing from the trust account and are trying to be readmitted, have a fairly hard job establishing that they're a fit and proper person to be readmitted. Theft is really taken, it's probably it's the ultimate form of dishonesty, and that's the thing that really draws a lot of attention. Things like failing to put in tax returns for barristers. There were many years when barristers had a terrible record of failing to put in tax returns, and that got to the point where that was seen as so heinous that they could be struck off for failing to do that, because it was seen as a form of dishonesty as well, in terms of potentially defrauding the public revenue. So,
excuse me, Stephen, I've got to go, mate. I'm at the library and they're closing up. So.
Oh, okay. All right.
I'll see you later. Thanks for that.
Okay, no worries. All right, look, so personal misconduct as well as professional misconduct can lead to, falling foul of these professional rules. And we'll look at more of that as we go through the course. The last little bit is about drink driving, actually. Should drink driving convictions affect law students seeking admission to the legal profession as well as practicing lawyers? There was a classic case there by Justice Howie who'd been handing down decisions against drink drivers and then got caught for drink driving himself. So it was the ultimate, betrayal, if you like, or terrible situation for the judge to be finding himself in. But anyway, what do you think about this? Is it something that should be taken into account for admission?
I think, again, it depends on the circumstances. So if you were a 17-year-old driver and you've been caught drink driving once, it's different to, being caught multiple times, and, it depends on the circumstances.
It does. It depends on things like whether it's low range, mid range, or high range offences. It depends on things like whether there's been first or multiple offences. How long ago did these offences occur? If there's significant instances of these, is there a problem that needs to have some sort of medical diagnosis? Is there treatment that's required before a person can be regarded as fit and proper? So there's a whole lot of factors go into these sorts of considerations, but it's certainly something that you would have to disclose for admission, and it would be taken into account as to whether you'd be admitted or not. But generally you'd have to have a few of these offences, and particularly if they're mid to high range, it becomes fairly serious. And of course, there's also the consequences. If there's property damage or injury to people as a result or consequence of your drink driving, that's in effect what Symes's situation was. So those sorts of things will be also taken into account. Other ones I'll just mention too, and you'll be looking at this when you get to admissions, but things like plagiarism are also taken into account for admission. And they're dealt with fairly harshly in Queensland. You've got to disclose them, and you can be grilled in an admissions ceremony by the Chief Justice as to plagiarism situations in front of everybody. So it's not something to ever fall foul of. So bear that in mind in everything you ever do. Make sure you cite things properly, because it comes up. Even in New South Wales on the board I was on, it came up all the time. So it's all about honesty, and plagiarism is a form of dishonesty. So yeah, so you need to be wary about that. Any questions about anything we've looked at tonight? I know we've gone pretty quickly. I'll post up a summary of all of this material into the discussion threads. Probably tomorrow. It's going to be late tonight, but I'll do that tomorrow. And I'll also put the film up on YouTube and put the link back in as well if you want to have a look at it again. All right. Any questions? No?
No.
Okay. All right, look, thanks for participating tonight. And as I say, see if you can get ahead a little bit in your readings so that you get a bit more space to handle week 4, because there's a lot of stuff in week 4. So I just want to make sure that you try and get a bit of a buffer for that week. Okay. All right, on that note, I think we might call it a night. So thanks very much.
Thank
Hope to see you all again next week.
Thank you.
Thanks, Professor.
Okay, bye.
See ya.
Bye.